A warm welcome to all of you to the webinar series hosted by Advocates Association Bengaluru. We have with us today Shri Nagendra R Naik, Advocate. Sir, we are happy to have you with us today. Welcome to the webinar.
Thank you. Thank you.
It's now time for me to introduce today's speaker. Mr. Nagendra Naik hails from Bhatkal district. After his primary education, Mr. Naik obtained his bachelor's degree from Anjuman Arts and Science College, Bhatkal, and later moved to Bangalore. He got his law degree from Dayanand Sagar College of Law and enrolled as an advocate in the year 1993. Immediately, he joined the office of Senior Advocate Shri P.S. Rajgopal. Regularly, Mr. Naik has been appearing before the Honorable High Court of Karnataka, Karnataka Administrative Tribunal, Special Court for Prevention of Corruption Act, Central Government Industrial Tribunal, and Labor Courts. Mr. Naik has represented bank trade unions before various courts and also represented the bank managements before industrial tribunals and advised them on issues relating to industrial relations. He has appeared in a number of criminal matters before various courts in Bangalore and outside Bangalore. He is also appointed as a special public prosecutor by the state government to appear on behalf of the victim in the Fraser Town rape case. Apart from his profession, Mr. Naik has interest in agriculture and his family has developed a floriculture farm. Sir, on behalf of Advocates Association Bengaluru, I extend a warm welcome to you. Over to you, sir.
Thank you, Vikram. Good evening, everybody. First, let me thank Mr. Rangnath and his team for taking this initiative. And I am keenly following these webinars on a regular basis. And they are selecting very good subjects. When they invited me, I thought the hot subject is Prevention of Corruption Act, because it is one of my favorite subjects. Though I started practice on service side with my senior Sri P.S. Rajgopal, the Prevention of Corruption Act trial were incidental, or we were having major cases along with our departmental inquiries. That is how I got interest in the PC Act and I started practicing. And I have conducted more than the 300, 400 trials on, complete trials on PC Act. And instead of referring to the several provisions of the Act and the judgment, which you can read on the SCC online, I feel if I share my experience as a trial lawyer, how to prepare for the defense as a defense advocate, that will help the younger generation to take up the career further. Let us have a look at, because the subject we have selected is Prevention of Corruption Act vis-a-vis bureaucracy. Bureaucracy is an integral part of PC Act, because unless there is a public servant, unless there is a bureaucrat or a politician, PC Act will not survive. See, there is both plus and minus, positive and negative things in the PC Act. And I would like to enlighten both the things, how the prosecution will take up the matters and how the defense will take up the matter and how the justice will prevail and what is to be seen at the end of the day and how we can curtail the corruptions. Just we will have let us have the brief of the background of the PC Act. You might have seen a lot of processions, protests, demanding special courts during Anna Hazare strikes, and each court has been granted additional 2 courts. They have granted additional finance for each state for combating corruption. These are one movement. If you look at the background, in India has seen 3 corruption acts. One is PC Act 1947. And PC Act 1988, and the major amendment to PC Act in the 2018. If you look at the date of commencement of the Act, it is very interesting. Corruption is not started in India or Indian mentality as you find criticism every day. Corruption, if you look at the dates of the Act, even prior to first PC Act 1947, that was enacted on 10th March 1947, even prior to independence. There was a provision under the IPC because IPC was enacted in 1860, and in IPC section 161 to 166, we can find the very same provisions what we are finding in PC Act. From the 1860, even before the independence movement started in 1857, the corruption cases were available in India. That means it is an inherited legacy from the British administration. I will not say British administration, it is inherited from administration. Even if you go little behind that, ancient history, if the concept of transfer is invented by Chanakya, because why the transfer is inducted into the administrative law is to prevent misuse of power and to prevent what happens when a person is allowed to sit in a particular office for several years, the misdeed he has done in his office during his tenure will not come to picture. That is why the transfer was invented for the time immemorial. Even in ancient history, we can see that there were transfers. And the PC Act, it is not like unless other criminal law. It goes with the administrative law. Because anybody who wants to practice Prevention of Corruption Act, he must be thorough with the administrative law. Because the administrative law principles are intrinsic with the provisions of PC Act. Suppose if you take up a case of abuse, there will be delegated power, there will be bias, there will be malafide actions, there will be ratifications, there will be malice. Every action of the administrative law is available when you are defending or prosecuting a Prevention of Corruption Act cases. I'll give the examples for that also. That is the reason what I am saying is PC Act and administrative law goes by side. Now we will go to the one particular set of cases. Then we will know how it goes by side. What happens when we look at the administration? We are calling the CBI, that is constituted under the Delhi Special Police Establishment Act. That was enacted in 1946, even before the independent India. That means the administration is struggling to curtail the corruption from even before the independence. If you look at the journals, the SEC reporting journals, the major cases we are looking at and we are finding after 1970. The first 20 years, we did not have major cases. Slowly, it has increasing. That means the mindset towards corruption has increased after 1970. Now, I will give an example. We will take a murder case. There, an accused is not authorized to do a murder. He will commit the murder, then allegation will be made, accused will be silent. It will be the duty of the prosecution to say, this man has committed murder and these are the evidences I am placing before the court to prove that he is the guilty. But in PC Act, it is not like that. We'll take the example of a bank manager. A bank manager is vested with his administrative power to sanction loan. He will sanction loan during his regular business. He is made to grant loan. He is paid salary to improve the business. Then in the process of the business, the manager is required to collect deposits. He has to help the customers. He has to grant the loan. He has to grant different facilities. Once the loan becomes NPA, then everything will start. Then the allegation starts. Then the vigilance will come into picture. First, the inspector will come. He will inspect the file. He will find out the loopholes. This application is not filled. You have not made pre-sanction inspection. You have not conducted post-sanction inspection. You have not complied this procedure. Then all this procedural law will come first. Then when they look at the procedures, then they will see whether there is a vigilance angle. Here the issue will come. Now you look at the definition of the misconduct under the PC Act. PC Act under section 13, what it says is, whatever the A, B, C, D, E, now it is not available because up to 18 it is amended. What I am talking about before amendment. Even now it is there, but it is in a different form. A, B, C, D, E, it says, if you do these things, it is a criminal misconduct. There is a difference between misconduct and criminal misconduct. Misconduct is liable for departmental action. The moment criminal is added to that, it is a case for prosecution under the Prevention of Corruption Act. When will we add misconduct, criminal misconduct? Then we will have to go to the definition of corruption. Ultimately, what is corruption? If you have to put it in a simple language, a dishonest intention is a corruption. What is dishonesty? Again, we will have to go to section 24 IPC. What it says? It says causing wrongful loss, causing corresponding gain with a dishonest intention. Now, if you have to attract section 13(1)(d) or E for criminal misconduct, we will have to establish that there is a criminal mind, there is an intentional commission of crime. Now, I was talking about the bank manager. What happens? A bank manager who granted the loan in the normal course, he would have taken the application, he would have seen whether this project is viable at that particular moment and granted the loan. Some subsequent event will make the loan default, NPA. He will not be able, the borrower will not be able to pay the loan to the bank. Then the question will start, what was the role of the manager? Then the immediate thing the inspection department will make is, they will say the manager is at fault in granting the loan. Here the defense lawyer's question will come. I will give the few examples. Before that, the Prevention of Corruption Act will have only 3 types of cases. I will deal one by one, then I will go to the bank manager again. It will have 3 types of cases. One is trap. Trap is, everyone know, the complainant will submit the complaint. They will make every arrangement to trap the public servant red-handedly with 2 witnesses. One will be the shadow witnesses. He will go with the complainant and he will go to the site, so the office of the accused. He will witness the whole incident, whatever transpires there. Then they will make a recovery and put up a case. These trap cases will happen, according to my experience, only in 2 circumstances. The first circumstances is when there is an accused harassment of the public servant to the publics. Then without, unable to bear the harassment, they will go and lodge a complaint either to the Anti-Corruption Bureau or CBI, whichever organization is there. If it is central government, it is CBI. If it is state government, they will go to the Anti-Corruption Bureau. Now, there are another type of cases. The second type of cases are a case of victimization. I will give 1 or 2 examples. I have seen many of the cases, even public servant will not know why that particular complainant was against this particular public servant, why he was making hectic effort to trap him. One example I wanted to give is, I had one case from NCT, National Council for Technical Education. He was a desk officer. He was trapped. The money, he has not accepted the money. He has came to the accused who had nothing to do with the file. He had no power to sanction. He will come, complainant will come to the accused and say, sir, my file is ready and you have to upload it to the website and please take this money. According to the complainant's version, this accused will tell him, no, I will not accept it. You go and keep it beneath that plant, which is behind the building. He will go and keep it beneath that plant. 6 o'clock, this official will come. He will come and sit in the car. He will not take that money. Immediately, the complainant will come and remove that cash and go and keep it in the car. Immediately, CBI people will come and raid and they will collect the money, and red-handed, the right hand wash will come to red. That in every case, they will make it red. It will come red. What happens when this took place and they filed the charge sheet, and the charge sheet came to me for defense? The first thing as a trial lawyer, what I do, it may help others. What I do is, I will prepare a synopsis and event, because trap case there will be few events. I will prepare the events with timings. I started writing the events. I wrote how in a sequence how it happens. And in all of the cases, invariably nowadays, the prosecuting agencies are recording the voice. They will take out the mobile conversation with the accused as well as the complainant. But there will not be a voice recording. In some cases, there will be voice recording. In this case, there was a call records. In the call record, when I was going through, I could find immediately after the trap, he has called one particular person. Then I just scanned the numbers. Then this complainant has called one of the particular person. I just scanned the number and I could find a new number. I asked him, who is he? Then he started, that accused started dialing in his mobile. He found that it is his co-employee. Then I told him why he has lodged a complaint, why he is involved in this. Then he told me, this man, against him I have lodged a complaint to my superior, stating that he is demanding bribe in my name, because he is a class 4 employee, and both of them are of the same name. In my name, he is demanding bribe from several publics who are coming to the office, and that has brought disrepute to me. That is why I have lodged a specific complaint against this man to the higher ups. Then I started scanning further. I could find there is lot of conversation between this class 4 employee and the complainant. Then we started tapping with the location of the towers, where this man was there, what time he was there. Then I started questioning, because he stayed in Nagarbavi for even previous day of the trap. But in the complaint, what he has said, morning he has come from the Andhra. Then I could find out there is something fishy. Then I started investigation on my own. I put up the specific defense. I could succeed in that case only on that complaint, because a third party involvement is there in the case. This type of incident I could find in 2-3 cases. I have taken similar defense and succeeded. And it is a fact. The co-employees are the biggest threat many times. In these type of cases, the first thing as a defense counsel, what we have to do is, we have to spend certain time with the clients and find out how their office works, how that crime scene is there, what is their background, is there any enmity. All these things we will have to find out. I am not saying there are many genuine cases. I was telling about the conduct. I have seen earlier the view was, the general way I am talking, the fresh IAS officers were never taking bribe. Nowadays, the morality has gone down. Now even the probationary IAS officers I have seen taking bribe. That is, this is very astonishing. And we have a case, even before the probationary is declared, they have been trapped in many of the cases, or they have been involved in many of the misconduct cases, abuse of power cases. It is mindset. I will come to that a little later, how it works. What I would like to say is, in a trap case, it will happen only for 2 major reasons, either for harassment or victimization. In these 2 type of cases, as a defense lawyer, we will have to put up a proper defense. It is not like, unlike other cases, without putting up the defense. Connection hoita? Vikram?
ಇಲ್ಲ ಸರ್, ನಾನು ವಿಡಿಯೋ ಆಫ್ ಮಾಡಿದ್ದೀನಿ, ನೀವು ಕಂಟಿನ್ಯೂ ಮಾಡಬಹುದು.
Okay. What I am saying is, in like other criminal cases, here we can't be silent. In a trap case, you can be silent, but it is always better to take a specific defense. This is one. In the case of abuse of power, that is second part of the case. This is the major cases we are getting in CBI, not in Lokayukta cases. Nowadays, it is there. Denotification, then granting land, all these cases will come under that. I will give a classic example how these cases will happen. These abuse of power cases, it is a very thin layer is there in this. The Central Vigilance Commission has periodically issued guidelines to the department to take up the cases only involving vigilance angle. Because in these cases, victimization is more. In one classic case, recently it is acquitted. There were allegation of 117 crores in a public sector bank. I represented one of the client who is the chairman of the bank. He retired in the year 1992, 30th June 1992. Then the case was filed in the year 1995, after 3 years of his retirement, for an incident of 1985. The first loan was granted in the year 1985. Continuously, there were three chairmen. It was granted in the period of 3 chairmen. So many GMs, so many AGMs and DGMs. Finally, they selected 8 and prosecuted them. The interesting part is, the bank has filed 3 complaints. First complaint was closed, saying that there is no case. Second complaint was filed, saying there is no case, and it is closed, there is no case. The third complaint was taken cognizance. Then the charge sheet was filed in the year 2000, after 8 years of the retirement of the 2 chairmen and GMs. Then the case was acquitted in the year 2018. Because of the voluminous record, nobody was ready to take up that case. Look at the fate of those chairmen. Here, the interesting part is, what the prosecuting agency was required to do the things, they have not done. The Central Vigilance Commission says, you have to bifurcate a line between a bona fide decision and a mala fide decision. What is bona fide decision? This is where I said, I have given the earlier example. The manager in a particular circumstances grants the loan. Then at the later point of time, the borrower will not be able to repay the loan. It is like Vijay Mallya. He has borrowed the money. He has paid highest tax, highest fuel. I don't know whether he has misappropriated or not. But ultimately, he could not run the business. There is a default. Whether it is willful default, whether criminal intention was there, it has to be proved. Second thing. But whether at the time of sanctioning the loan, whether there was a dishonest intention is the question. So courts will have to judge the things with the circumstances on hand on the date of sanction of the loan, not the subsequent events. Because otherwise, it is a contractual matter. What the prosecution has to prove is, on the date of entering the bank by the borrower, whether there was a dishonest intention. Because in a contractual matter, if the dishonest intention is not appearing on the date when he has entered to the bank, then it is not a case of cheating. It is a case of simple contract. Here, it is easy to make allegation against every individual who is exercising the power, but it is very difficult to prove. But the ordeal they are facing, the administrative members are facing, the officers are facing, that is unbearable. Because I have seen in many cases, even in my case, that chairman, his 3 children are settled in US. He could not go to US from 1990 till 2018. And most of the time, he had 3 cases. All 3 cases are politically motivated. The interesting part of it is, I was talking about the third complaint. The third complaint was registered after one of the property of the CBI director was purchased by the Vijaya Bank. This I have brought it in evidence in a defense. See, look at the fate of the chairman. Generally, when you make an allegation saying that there is 117 crore fraud, everybody will be carried away with the impression that these people have committed fraud. Nobody will come to the rescue of the officials. That is where the policy paralysis will happen. This is how it happened in 2G. There is a reason for amendment of 2018 PC Act. 2018 PC Act, whatever the amendment has been made, the first draft has come in the year 2013. Do you know the reasons? The reason is, in the central government, after this 2G and Colgate cases, there was no secretary who was willing to sign the file. Because whichever secretary who has signed the file, they were in jail. They felt it is better, it is safe not to sign the file. Thousands of files were pending. Then government felt we have to amend the rule. We have to safeguard the at least honest public servants. Then they proposed an amendment in 2013. That first amendment was passed by Lok Sabha, but Rajya Sabha did not pass it. Then again it has failed. Then again in 2016 they have passed it. Then in 2018 Rajya Sabha cleared it, and the total shape of the act is changed now. Some people are talking it is amended to help the public servant. No. They have seen the lot of cases where the courts could not have understood the real intention of it. The problems, I will say, there are third category of cases, the disproportionate asset cases. The 2018 amendment, which has taken care of the trap and abuse of power abuse cases, as well as the disproportionate asset cases. The earlier definition, if you look at the 13(1)(e), whatever income you have not reported to your employer, it is not counted by the prosecution for lawful source. There were certain examples I could give. A public servant has a building. He will declare the building. He will receive the rent through check. But that check is not declared to rent is not declared to the department in the annual assets and liability statement. Court will say in a trial, you have not declared it in your assets and liability statement, we will not take it as income. In the result, the lawful income of the public servant was not taken into account. This was causing a lot of problem to the public servants in defending the case of disproportionate asset. Then what happened? The definition is changed now. Now it says any income from lawful source is acceptable. That means now the public servant burden is relieved. He will have to show that whatever income he has taken, whatever income he has received, it is from a lawful source. Therefore, my observation of the amendment is there is no intention to help the public servant. The intention was to protect the public servant from unlawful prosecutions. Now, how the courts will look at the prevention of corruption cases. I will not refer to the judgments. You might not have come across quashing of prevention of corruption cases by any court, barring few. At the stage of discharge, courts are very reluctant to say, we will not consider your discharge application because it is a PC Act. In my view, as a defense advocate, I feel this causes a lot of injustice to the litigants. The preconceived notion is not correct in judicial dispensation system. One of my client, he is a junior of one particular advocate. One CBI files a prosecution. The allegation is they have filed one motor vehicle claim. That claim is fake. Accident has taken place somewhere. they have bought some injured person and made a fictitious claim. Therefore, it is a case of a false claim. The worst part of it is one of the junior working with him signed on the presentation form, presented by so and so, and signed it and filed it before the court. He has no role. He has not met the client. He has no intention to commit it. Senior, whether he did this cheating, fraud, whatever it is, let it be decided in trial. He is accused number 2. My argument before the court was, this man has done nothing except signing on the presentation paper to present it. He has no role. Please discharge him. But unfortunately, that was not done. The biggest loss caused to him is he was selected as Munsif. And he lost the opportunity to serve the judiciary. I'm not saying whether right or wrong, but at least for my view, that trial is not completed now. It is almost 5-6 years. The man lost the opportunity, and we cannot put the clock back and make him a Munsif again. It is his lifetime opportunity he missed. That is why what I am personally feeling is, if it is a case to be seen as a case, we have to go with the evidence. We have to analyze it, and if it is not a case for prosecution, you have to close it. Otherwise, this man will suffer it for several years. As I said with the public sector bank case, he lost his entire retired life in courts. In 3 cases were there, all 3 cases are acquitted. And every presiding officer looking at the records were worried, who will deal with it? This is so many cases, so many crores allegation. But at least there are good judicial officers. They have taken pain. They have, one judicial officer has heard this matter for almost a month. And because there were 8 to 9 accused, every day he heard it for full day, and he has taken pain, and courageously he has acquitted it. And I am, at least for my experience, I feel it is a right judgment, and he has appreciated every fact of it. That is the reason those who are dealing with the Corruption Act, PC Act cases, I personally feel they should know how the bureaucracy works, how the bank works, how the public sector works. We have to sit in the chair of that officer and see, if I were given that opportunity to serve as a public servant, what I would have done, whether he has done it properly or not. Because it is not that whether that decision is right or wrong now. In a given circumstances, whether that judgment is right or wrong. Today that judgment may be wrong. That doesn't mean that he is corrupt. That is the reason I am saying bureaucracy and administrative law plays a major role in deciding the cases of corruption. And every advocate who wanted to practice in this field should be thorough with the administrative law. And I will give an example how the administrative law came into picture in this case. When my client, he was about to retire on 30th June 1992, a board note will come to him saying that there is a customs going to auction the properties of the company. We have to pay around 50 crore amount to the customs duty, and the company has no money. The customs duty is not paid. The whole property will be auctioned, and the company's whatever loan is given by the bank, that entire loan will be wiped out. Then it is a Hobson's choice. He has to decide either this way or that day. He was on the verge of retirement because that is the day on which he retires. Then what did he do? He called all his general managers and he constituted a committee. He discussed it with the general managers and said, what is the decision we are going to take? Everybody said, we will take a decision to pay the customs duty and protect the asset of the company. They decided, they granted additional another 50 crores and saved the auction, saved the property of the company. When this was done, it was placed on the next board meeting. Board has ratified it. this action was ratified. And subsequently, even after retirement, the another MD who has taken over granted another 15 crores. That means here the ratification question came. One of the points we have argued is whatever action I have taken, it is ratified by the next MD and the board. And after that, my successor in office has also granted another additional 17 crores. That means the decisions which I have taken at the given point of time is a bona fide decision. Court agreed with it. What I would like to emphasize here is the question of ratification has saved me there. This is not in one case. In so many cases, we will take this. See, the administrative machinery, the ratification is the biggest part in the banking system. The best thing the administrative structure having is transparency. What the court has to see or the defense has to put up is every public servant has to say in a defense that my dealings are transparent. I brought it to the notice of the head office. They are in the knowledge of it. If you have not taken this defense, it is very difficult to defend a case of abuse of power. Because I will have to prove that I was not doing anything with a criminal mind, with an intention to causing loss to the establishment and having corresponding gain to the public. This is exactly the defense every case the lawyer has to put up, according to me. Because in other criminal cases, we need not put up this defense because there they are not allowed to do that, discharge that function. A person is not allowed to commit murder. A person is not allowed to assault someone else. They cannot justify that. They cannot take a specific plea. Here, every public servant is required to take a proper defense that my actions were justified for this reason. I had no bad intention in doing this. This will be the thing. In a case of disproportionate asset, there will be many of the assets the public servant has acquired. In one of the incident, it is a case, conviction case. It was very interesting. The problem is that man, he was working in a public sector undertaking. He was very conservative man. He was depositing 1,000 rupees for 1 year. And he will get 1,130 rupees along with interest. What he will do, he will remove this from this bank and another bank will give him another 0.5% interest extra. He will go and deposit in that bank. This is how he made so many deposits, but by the end of the trial, I could not produce any document to say that it is an interest earned because the bank will not have the documents for that. This man is prosecuted after 30 years of his service. Whatever deposits he has made in the last 30 years, I was not able to prove. Then there was a disproportionate asset and he was convicted. Personally, I feel he's a victim because he did it, but he is not able to prove his defense. And one more case, presently it is under trial. A municipality member has been prosecuted. The allegation is he has amassed wealth as a municipality member. But he is a big businessman. Continuously, he is a member of municipality for almost 40 years. When the notice was issued by ACB, I wrote a reply to the ACB. All right, he is a public servant according to your definition. But tell me, under which law he is supposed to declare the asset? Because as per the section 13(1)(d) of 13(1)(e) of the PCA Act, he should declare the asset as per the law applicable to the public servant. Now, my question is, the Representative of People Act is not applicable to him. Then the conduct rules is not applicable to him. There is no law which mandates municipality member to declare his assets. But unfortunately, they have not said, they have not given any reply. They filed a charge sheet. Now the question is, he was not aware I should maintain an account for my deeds, and after 40 years, I will face this prosecution. Now, after 40 years, he is facing the prosecution, but where is the document to prove? If I give an application to the bank to give me fast sheet of last 40 years, bank says we have no records. Income tax says we have no records. This is the problem they are facing. These are the practical difficulties. Here, if the CBI is given the choice of prosecution, they are doing it professionally, because the prosecuting agencies also will differ. What they will do, they will take the entire period. They will select a particular period where the asset is amassed in a disproportionate way, and they will select that particular check period as a check period. It may be 5 years, it may be check period 10 years, and they will tell, in this period you have amassed wealth and you disprove this. Then it is easy. He can put up the defense because it will be nearer to the raid. But in Lokayukta and ECB, they will take from the day one. If the public servant has joined in 1970, they will take the check period from 1970 till his retirement. It is very difficult to prove. These are all the defense problems faced by the public servant. That is the reason, to avoid this, this 2018 amendment has come. Now, there are a lot of cases on sanctions. I don't want to touch those cases, those issues, and refer to the sanctions. Time given to me is 1 hour. I feel the almost it is 45 minutes. Vikram, will we continue or will we go with the question and answer session?
Please continue till 7 o'clock, sir. Post 7 o'clock, we can go ahead with the Q&A session.
Okay. Now, I will come to the question of sanction. What happens? I'll give an example of discharge case. In one case relating to a public servant, we have conducted the trial. We have examined the sanctioning authority. At the time of judgment, court felt that sanction is not in order. Then court discharged the accused. Then CBI bought the sanction. By that time, the public servant was dismissed from service. CBI filed a second charge sheet. My argument was, there was no chance for discharge at the stage of judgment, because if it is to be a discharge, it has to be at the stage of HBC, not after full trial. But court felt, no, trial is permissible. Trial was conducted with the same evidence. They convicted him. The court convicted him. Now, it is pending in appeal. After several years, now Supreme Court said, once the accused trial is completed, the issue of sanction cannot be decided at that stage. Now, even if you decide that sanction is not proper, there cannot be a second trial. But look at the ordeal of the man who has faced twice the trial. Almost, this is the case of 1995. The first acquittal was in 97. Then the second charge sheet was in 2001. Then the second conviction was in 2010. The entire life he is ruined in the court. If the law is not settled, or the prosecuting agency, defense, or the presiding officers, if they have not interpreted the law properly, and if a wrong judgment or if a wrong prosecution takes place, the suffering of the public is huge, and the man's life is totally sealed. One more example I will give how the public servant will take misuse of the things. One incident took place in Corporation Bank. There were 2 DGMs, and both of them are competitors for the next post. aged DGM was working in one particular division. He granted certain loans. Those loans, one of the loan was NPA. The successor DGM, who is junior to the DGM, who occupied the office, he or she wrote a letter that this is a case which has to be referred to the CBI. They referred to the CBI and an FIR was registered. Then that DGM became an accused. The senior DGM became an accused. By the time senior DGM became an accused, their DPC started. In the DPC, when they started looking at the profiles, the senior DGM is facing a criminal case. He has been ignored. Then the next DGM came to picture. Though he or she is junior, she has become GM. Next, she became executive director. Next, she has not occupied the chairman. She became the executive director and retired. Look at the fate of the man who was facing the trial. He was in court. Luckily, and I remember this case because that is the only case in my professional career of 27 years. The judge who granted the bail has completed the trial, and we have completed the trial within 10 months. And the surprising part is we have examined 154 witnesses. And one accused was in US. Then I requested the court, because it was a case for discharge, I argued. The judge said, it is a prevention of corruption case. I will not definitely discharge, even you make your effort. But if you are ready, I will take up for trial. I said, I am ready. Then the judge issued summons every day for 10 witnesses. 3 or 4 witnesses will come to the trial. And we have examined that. And that was the case where one of the accused had recording of implementation of project from the scratch, day 1 till the production. I made a video presentation. I requested the judge. The allegation is, we have taken the loan, we have not implemented the project. It is not so. I will demonstrate before the court every day's action and whoever has visited. I started playing video, and every witness, many of the witnesses, those who have gone for inspection, they were before the court as the witnesses. Then I have shown this witness has appeared before visited the site on so and so. He has submitted a report like this, and this is the report. And there were some wrong report also that we could show that it is a wrong report. And ultimately, I called the accused thrice. That girl, who was one of the accused, came to the court on the first day of appearance for executing the bail bond, on the second day of appearance for executing for the charge, and third date for 313, and last for judgment. And only 4 times. And this judicial officer was so considerate when I told him she has recently married, the husband do not know that the CBI case is pending. And if you insist the presence every day, and he will know, there may be problem in her personal life also, because she is one of the borrower. Then he said, all right, we will protect her interest. You keep her present only when it is required. I called her 4 times in a year from US only to attend the case. And later I came to know this was a case where twice the IO as well as the prosecuting agency has requested for closure, but only for statistical purpose this case was filed. Look at the damage caused to the accused. There are 10 accused. They were continuously appearing, leaving all their job. The main accused lost his opportunity to become ED of a bank. And by putting a false case, the man who or lady who is not eligible to become the promotion, she got the promotion. They become these public servants become the victim of the total system. That's why what I would like to say is, if the judiciary is not vigilant to bifurcate, or if the administration or the senior administrative officers are not vigilant or honest in doing their things, there will be a lot of problem for the bureaucrats. even for honest bureaucrats. I am not talking about the corruption. There are cases. There is a straightaway cases will be there. I will give you an example of corruption. One bank manager opened an account. He transferred all monies to his share account. He traded every day, lost 6 crores. He came with a charge sheet to me and said, sir, they have given charge sheet to me. I asked him, will you expect the award from them for having whatever you have done? They have done the right thing. Then I told him, this is not a case defendable. And I sent the file because everything he has done on record, that from this account to that account to this account, and the money trail is clearly visible. This is not the case where we can defend. Really, we can defend the cases where the public servants are victims. Their fate is well known to the only defense side. You have to look at their fate. They will be dismissed at the middle age, at the 45 or 50. They will not have employment, and many of them are dismissed on the date of retirement. I can give a number of cases on the date of retirement they have been dismissed. These are the cases. This will happen because we are not aware about the law. We are not aware about the profession. It is not we means not the advocate. The persons who are discharging the power of prosecution or power of the vigilance, all those people, they will have to read the vigilance manuals, vigilance things. They will have to try to bifurcate the bona fide decisions. Only then a real cases will come for prosecution. Otherwise, what happens? There will be a lot of allegations in public. You might have seen. There will be a lot of acquittals. It is not just acquittals. The cases will be like that. One of the judge observed for catching a rat, you are digging the entire mountain. This is what he has observed in one case. Many of the cases we have seen, without making proper diligence, they will initiate the prosecutions. Therefore, what I am saying is, now we will go to the Corruption Act, the existence of Corruption Act again. I was telling from ancient time till now, the Corruption Act is in force. And India is not only the country. You see the World Corruption Index. Every country has corruption, including US, Australia, and New Zealand. We should not say that India is corrupt, because that is, we are degrading ourselves. What I am saying is, it is not like allopathy and Ayurvedic. We should not use allopathy. What we are using is allopathy. We have to go for Ayurvedic. We have to treat the root cause for corruption. What is the root cause? A greedy mind. Now, unless, it is my personal experience, what I have felt, unless we train the younger generations from their childhood, giving them moral education. Now, during our period, there was at least one period for moral education. Now, I think it is not there in syllabus. Unless you make them morally responsible, unless everybody is asking their conscience what I am doing, whether it is right or wrong, whatever law you bring, that will not reduce the corruption cases. That's what I wanted to conclude. It's almost 7, Vikram. We will go for question and answer series.
If you want, you may continue for about 7 minutes, sir. We still have time, but if you want me to continue with Q&A, we can do that as well.
We will go with the question and answer, because I can refer to several judgments, but I feel judgments are available in the net. What I thought, my experience as a defense counsel and how to put up the defense may help the younger generation. That is why I have more concentrated on this.
Indeed, sir. Thank you very much for sharing the valuable insight. Now, let us move on to the Q&A session. I see Mr. Gupta is very curiously has raised his hand. All right, I would
Please.
unmute him. We'll
Yes.
start with Mr. Gupta. Sir, I have unmuted you.
No. Thank you, Vikram.
Thank you, sir.
Nagendra R Naik,
Yes,
you have
sir.
given an insight of this act, PC Act.
Yes, sir.
ನೀವು ತಾವು ಹೇಳ್ತಾ ಇದ್ರಿ 1947 ಅಂತ.
ಸರ್
ನನಗೆ ನಮ್ಮ ಹೈಕೋರ್ಟ್ ನಲ್ಲಿ ಚೀಫ್ ಜಸ್ಟಿಸ್ ಆಗಿದ್ರು DM ಚಂದ್ರಶೇಖರ್ ಅಂತ. ಅವರೊಂದು ಅಸೋಸಿಯೇಷನ್ ಬಂದು ಒಂದು ಭಾಷಣ ಮಾಡ್ತಾ ಇದ್ರು. ಅಕ್ಬರ್ನ ಕಾಲದಲ್ಲಿ ಅಕ್ಬರ್ನ ಕಾಲದಲ್ಲಿ ಅವನ ಕ್ಲೋಸ್ ರಿಲೇಷನ್ ಇದ್ರಂತೆ. ಹಿ ವಾಸ್ ಮೇಕಿಂಗ್ ದಿ ಮನಿ. ಎಲ್ಲಾರು ಅಕ್ಬರ್ನ ಹತ್ರ ಹೋಗಿ ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ತಾರೆ, ಇವನ್ ನಿಮ್ ಬಹಳ ಕಷ್ಟ ಕೊಡ್ತಾ ಇದ್ದಾನೆ, ಹಂಗಾದ್ರೆ ಅವ್ನ ದೂರ ಹಾಕಿ ಒಂದು ಸಮುದ್ರದಲ್ಲಿ ನಿಲ್ಸಿ ಅವನ್ನ ಅವ್ರಿಗೇನು ತೊಂದರೆ ಕೊಡದಾಗಿರುವಂತ. ಅವನ ಅಲ್ಲಿ ಬರೋ ಹೋಗೋ ಹಡಗ್ಲಾಗಲ್ತ ದುಡ್ಡು ವಸೂಲಿ ಮಾಡೋದಂತೆ. ಆದ್ರಿಂದ ಈ ವಸೂಲಿ ಮಾಡೋದು ಅವ್ರಿಗೆ ಬಂದ್ಬಿಟ್ರೆ ಅವ್ರಿಗೆ ಎಲ್ಲಾದ್ರೂ ಇರ್ಲಿ ಬಿಡೋದಿಲ್ಲ ಅವರು. ಈವನ್ ಮಹಾಭಾರತದಲ್ಲೂ ಇದೆ, ಇದೆಲ್ಲ ಕಥೆಗಳಿದ್ದೇ ಇದೆ. ಇವಾಗ ನೀವು ಹೇಳ್ದಲ್ಲ ಒಂದು ಪಾಯಿಂಟು ಮೊರಾಲಿಟಿ. ಅದು ಮೊರಾಲಿಟಿ ಬಂದ್ರೆ ಎವ್ರಿಬಡಿ ವಿ ಕ್ಯಾನ್ ಸೇವ್. ಬಟ್ ಕೊಡೋರ್ಗೂ ಇದಾರೆ, ತಗೊಳ್ಳೋರು ಇದಾರೆ, ಇಬ್ಬರದು ತಪ್ಪಿದೆ. ಇಟ್ ಇಸ್ ನಾಟ್ ಒನ್ ಸೈಡೆಡ್, ಬಟ್ ಇಸ್ ನಾಟ್ ಓನ್ಲಿ ಅಫಿಷಿಯಲ್. ಇವ್ ನಮ್ಮ ಹತ್ರ ಬೇಗ ಕೆಲಸ ಆಗ್ಬೇಕಾದ್ರೆ ನಾವು ಕೊಡ್ತಾ ದುಡ್ಡು ಕೊಡ್ಬಾ ಈಗ ನಾವು ಮಾಡ್ಕೊಳಪ್ಪ ಅಂತಾರೆ. ಫೀಸ್ ಕೊಡಕ್ ತೊಂದರೆ ಇದ್ ಮಾಡ್ತಾರೆ, ಲಂಚ ಕೊಡಕ್ ಮುಂದೆ ಬರ್ತಾರೆ. ದಟ್ ಈಸ್ ದಿ ಆಟಿಟ್ಯೂಡ್ ಆಫ್ ಅವರ್ ಪಬ್ಲಿಕ್. ಸೊ ವಿ ಹ್ಯಾವ್ ಟು ಫಸ್ಟ್ ವಿ ಹ್ಯಾವ್ ಟು ಡೆವಲಪ್ ವಿತ್ ದಿ ಕ್ಲೈಂಟ್. ಎಲ್ಲರಿಗೂ ಹೇಳ್ಬೇಕು. ಇವಾಗ ನಿಮ್ಮ ಕೋರ್ಟ್ ನಲ್ಲಿ ಫೈಲ್ ತೆಗಿಬೇಕಂತ ಏನ್ ಮಾಡ್ತೀರಾ ಅಲ್ವಾ ಸರ್? ನೀವ್ ಹೇಳಿ.
ಇದಾರೆ ಅಲ್ಲೂ ಆನೆಸ್ಟ್ ಇದಾರೆ ಸರ್. ಎಷ್ಟೋ ಜನ ದುಡ್ಡು
ಹೇಳ್ತೀನಿ ಕೇಳಿ. ಕೆಲವರು 5 ರೂಪಾಯಿ 10 ರೂಪಾಯಿ ಸಿಗಾಕೊಳ್ಳೋದು, ಅವ್ನ 5 ಕೋಟಿ 10 ಕೋಟಿ ಸಿಗಾಕೊಳ್ಳೋದಿಲ್ಲ. ದಿಸ್ ಇಸ್ ಆಲ್ಸೋ ದಿ ಬ್ಯಾಕ್ ಗ್ರೌಂಡ್ ಇದೆ ತಪ್ಪು ಇದರಲ್ಲಿ ಇರೋದು. ಐ ಥಿಂಕ್ ದಿ ಲೆಜಿಸ್ಲೇಚರ್ಸ್ ಅವರೇ ಬಿಡಿ, ಪೊಲಿಟಿಷಿಯನ್ಸ್ ಅವರೇ ವರ್ಕ್ ಮಾಡ್ತಾರೆ, ನಾವೇನು ಮಾಡಕ್ಕಾಗೋದಿಲ್ಲ. ಅಲ್ಲಿಂದಲೇ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ
ರೂಟ್ ಕಾಸ್. ಅದಕ್ಕೆ ಹೇಳಿದ್ದು ಮೊರಾಲಿಟಿ ತಂದು ನಾವು ಅವ್ರನ್ನ ಮನುಷ್ಯರನ್ನಾಗಿ ಮಾಡದೇ ಇದ್ರೆ ಇಟ್ ಇಸ್ ಡಿಫಿಕಲ್ಟ್ ಟು ಪ್ರಿವೆಂಟ್ ಕರಪ್ಷನ್ ಅಂತ.
ಸರ್ ಐ ಅಗ್ರಿ ವಿತ್ ಯು ಸರ್. ಫಸ್ಟ್ ನಾವು ಚೇಂಜ್ ಆಗ್ಬೇಕು ಸರ್. ನಾವು ಕೊಡಲ್ಲ ಅಂತ ಹೇಳ್ಬೇಕು ಸರ್, ಆವಾಗಲೇ ಸರ್ ಹೋಗುತ್ತೆ
ಸರ್. ಈಗ ಏನಾಗುತ್ತೆ, ಈಗ ಒಂದು ಪಾರ್ಟಿಯಲ್ಲಿ ಗೆದ್ದು ದುಡ್ಡು ತಕೊಂಡು ರಿಸೈನ್ ಮಾಡಿ ಹೋಗಿ ನಿಂತ್ಕೊಂಡಾಗ ಇನ್ನೊಂದು ಪಾರ್ಟಿಯಲ್ಲಿ ಗೆದ್ದು ಜನ ಓಟ್ ಹಾಕ್ತಾರೆ ಅಂತಂದ್ರೆ
Mr. Harish raised the same thing. He lost the election, but he backdoor enters. He came into the legislative council. I think Harish was right.
Everywhere it is there. That is the reason we have to treat the root. That is the reason I said Ayurveda.
That is also a corruption, sir. That is also a corruption.
Howdu sir.
Okay, thank you, Nagendra. Thank you, Harish.
Thank you. Namaskara, sir. Excellent presentation. Sir, Satnarayan Gupta ಅವರು ಹೇಳಿದಂಗೆ ರಿಯಲ್ ಎಸ್ಟೇಟ್ ಅಲ್ಲಿ ಅವರು ಇದ್ದಾರೆ, ನಾನು ಐ ಆಮ್ ಆಲ್ಸೋ ಡೂಯಿಂಗ್ ಫಾರ್ ಬಿಲ್ಡರ್ಸ್ ಅಂಡ್ ಥಿಂಗ್. ಲಂಚ ಕೊಡಕ್ ಸಬ್ ರಿಜಿಸ್ಟರ್ ಆಫೀಸಲ್ಲಿ ರೆಡಿ ಇರ್ತಾರೆ, ಲಾಯರ್ ಫೀಸ್ ಕೊಡಕ್ ರೆಡಿ ಇರಲ್ಲ. Okay. So I want to share with you one more incident. I had the opportunity when 2013 amendment bill was being tabled. It went before the select committee of the Rajya Sabha. I had the occasion to send my comments at the behest of another organization sitting in Delhi, who had asked me for my comments on this particular draft bill to be forwarded to the select committee, in which I had mentioned 2 definitions to section 7 and 8 when it was to be amended. Okay. One is coercive bribe giver, and the other is collusive bribe giver anta.
Yes.
These 2 distinctions need to be put into the act anta. Of course, collusive bribe giver ಅನ್ನೋ ವರ್ಡ್ ಇಲ್ಲದೆ ಇದ್ರೂ collusive bribe giver ಗೆ ಪನಿಷ್ಮೆಂಟ್ ಇದೆ ಅಂತ ಅಮೆಂಡ್ಮೆಂಟ್ ಅಲ್ಲಿ ಆಗಿದೆ. ಓಕೆ, ಕಾರ್ಪೊರೇಟ್ ಗಿಫ್ಟ್ ಗೋ ಎಲ್ಲದಕ್ಕೂ ಆಗಿದೆ. ಬಟ್ ಐ ಸ್ಟಿಲ್ ಫೀಲ್ these 2 words, though my suggestion on these 2 words have not been directly put into the amendment act, I still feel, don't you think that these 2 words need to be visible also in the act, so that people will know what is a collusive bribe giver? ಇವಾಗ ಎಲ್ಲ ಟೆಂಡರ್ ಗಳಲ್ಲಿ collusive bribe giver ಆಗ್ತಾರೆ. ಹಾಸ್ಪಿಟಲ್ ಗಳಲ್ಲಿ, ಗವರ್ಮೆಂಟ್ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ನೋಡಿ, ಹೆರಿಗೆ ಟೈಮ್ ಅಲ್ಲಿ ಹೆರಿಗೆ ಆದ ತಕ್ಷಣ ಮಗು ತೋರ್ಸಕ್ಕೂ ಲಂಚ ಕೊಡಬೇಕು ಮನೆಯವರು. ದಟ್ ಈಸ್ coercive bribe giver. ಇಲ್ಲಾಂದ್ರೆ ಕೊಡಲ್ಲ. ಔಷಧಿ ಕೊಡಕ್ಕೂ ಲಂಚ ಕೊಡಬೇಕು. Even now in COVID times you can see this in government hospitals happening. So I was having this feeling that these 2 definitions need to be visible in the act, so that people will know what it is also.
What I feel, these 2 cases can be covered in the present provisions. Both the coercive and collusive can be covered under the provision. It is not the law what is required. That is the reason I said, unless you make up your mind that, at least let me be honest, allivaregunu we will not be able to stop it. And I will tell you, see, if you look at the mankind, This corruption has started with the mankind and end with mankind. As long as human beings are there, corruption will not stop. You can only reduce the degree. Voice mute agide.
Sir, your voice is muted. We are not able to hear you.
ಮನೆಯಿಂದ ಶುರು ಆಗುತ್ತೆ. ಚಾರಿಟಿ ಬಿಗಿನ್ಸ್ ಅಟ್ ಹೋಮ್ ಅಂದಂಗೆ ಮನೆಯಲ್ಲಿ ಮಗು ಹೇಳಿ ಮಾತು ಕೇಳಲ್ಲ, ಚಾಕ್ಲೇಟ್ ಕೊಟ್ಟು bribe the child also. So this is how the corruption starts from home also.
Correct.
Thank you, sir. Thank you.
Thank you, sir.
Thank you, sir. Mr. Puttige Ramesh, sir, you can go ahead with your question.
Thank you, Trivikram. Namaskara, Nayak. So, Mr. Nayak, under the PC Act, who should start the proceedings? Under Section 13 says, the ACB can take action under like this. And they can start on their own or on a complaint. The complainant can be government also.
Sir, government can be the complainant.
Yes, government can be the complainant. But can the government say, you take action under these provisions?
To whom?
To the ACB. You inquire, you look into the matter. And
Definitely, sir. Definitely they can, because it is like a suo motu complaint.
No. Government initiates the proceedings and gives a complaint to the ACB.
Yes, sir.
ACB, they say, you look into the matter and then take action under these provisions.
Sir, it will happen. Yakantandre, ಈಗ ನೋಡಿ, I will give an example. ಈಗ ಮೈನಿಂಗ್ ಕೇಸಸ್ ಅಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನಮ್ದು ಇವ್ರದ್ದು ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಇದೆಯಲ್ಲ, ಅವ್ರದ್ದು ಹಿರೇಮಠ ಅವ್ರದ್ದು ಅವ್ರದೊಂದು
ಪಬ್ಲಿಕ್ ಇಂಟ್ರೆಸ್ಟ್.
ಹೌದು, ಅವರು they referred the matter to the CBI and said, that committee, and they said you submit a report. Once the report came, that report was sent to the CBI and said you take action according to law.
No, that's fine. No. I agree. You take action in accordance with law, but can they say you take action under Section 13(1), 13(2)?
Then they will have to take it as a complaint. That becomes the first complaint. When they say ACB is a police station,
right?
Government is sending a complaint to the police station to take action against the particular official.
Fine. Till then, no problem.
Provision. Then it becomes a complaint.
Fine. But there in the complaint, they say, look into the matter and then take action under 13(1) and 13(2). 1C and 2.
Yes.
So they can say, you look into the matter and say,
sir, now what happens?
Take action, register a case under 13(1C) and 13(2).
Yes. Tagobod, sir. It becomes a complaint. See, CRPC nalli, the ACB is a police station. They don't have separate status. They have to function under CRPC. Whatever procedure is available in CRPC, same procedure are available for PCA.
No.
Because PCA, other than describing the offense, it will not have any other procedure.
No, Mr. Naik, I have no dispute on the power of the government to lodge a complaint.
Yes.
And they direct the ACB to take action under these provisions.
You are saying direction.
A direction to take action under these provisions. For example, I lodge a complaint to the police station and then look into the matter and take action. But can I say you register a case under Section 302, 304 or 376 ಅಂತ ಹೇಳಿಕ್ ಬರುತ್ತಾ? It is
ಈಗ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ನಾವು ಬರೆಯುವಾಗ, ಅಡ್ವೊಕೇಟ್ಸ್ ಬರೆಯುವಾಗ, ಇಂತಿಂತ ಸೆಕ್ಷನ್ಗೆ ನೀವು ಕಾಗ್ನಿಷನ್ಸ್ ತಕೊಳ್ಳಿ ಅಂತ ಬರಿತೀವಲ್ಲ ನಾವು. ನೀವು ಇಂತಿಂತದ್ದು ಅಪರಾಧ ಮಾಡಿದಾನೆ, ಇಂತಿಂತ ಸೆಕ್ಷನ್ಗೆ ನೀವು ಕಾಗ್ನಿಷನ್ಸ್ ತಕೊಳ್ಳಿ ಅಂತ ಬರಿತೀವಿ. See, police, whether they will take cognizance or not, different thing. But when I make a complaint, I will say these are the offenses have been committed.
But ನಾವು ಹೇಳಲಿಕ್ಕೂ ಸರ್ಕಾರ ವ್ಯತ್ಯಾಸ ಬರುತ್ತೆ. ಬಿಕಾಸ್ ಸರ್ಕಾರ ಹೇಳಿದ ಮೇಲೆ FIR ಹೇಳಿದ್ದಾರೆ. ಸರ್ಕಾರ
ಅನಾಲಜಿ ಕೊಡ್ತೀನಿ ನಿಮ್ಗೆ, ನಾನು ಒಂದು ಅನಾಲಜಿ ಕೊಡ್ತೀನಿ. ಈಗ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಒಂದು ಫ್ರಾಡ್ ಆಗತ್ತೆ. ಬ್ಯಾಂಕ್ನವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ, ಅದನ್ನ ಬೋರ್ಡ್ ಇಡ್ತಾರೆ. ಬೋರ್ಡ್ನವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ, ರೆಫರ್ ದ ಮ್ಯಾಟರ್ ಟು ದಿ CBI ಅಂತಾರೆ. ಆವಾಗ ಅಲ್ಲಿ ವಿಜಿಲೆನ್ಸ್ ಆಫೀಸರ್ ಏನ್ ಮಾಡ್ತಾನೆ, ವಿ ಹ್ಯಾವ್ ಕಂಡಕ್ಟೆಡ್ ಅನ್ ಇನ್ಸ್ಪೆಕ್ಷನ್, these are the irregularities these people have committed. Take action under for so and so provision and the complaint kodtare. It is just akin to that alwa, sir.
No, then it is after investigation by the CBI.
Investigation ಏನಾಗೋದಿಲ್ಲ. Then after investigation, they will take.
FIR is filed. FIR is filed as per the government. We are taking action under these provisions before investigation.
ಅಲ್ಲ, ನನ್ನ ಪ್ರಕಾರ ಅದೇನು ತಪ್ಪಿಲ್ಲ ಅಂತ ಅನ್ಸುತ್ತೆ.
Okay. Yes.
Thank you, sir. I think there was some technical issue in between. I'm not sure if you are able to hear me. Could you please confirm that to me?
I can hear.
Oh, all right. I think the question posed by Mr. Putiga Ramesh is answered. If that is the case, then we can go ahead with Mr. Venkat Narayan. I lost the connection in between, so I don't know what happened. So if that is the case, we can go ahead with Mr. Venkat Narayan. I have unmuted you, sir. Please go ahead with your question.
ಸರ್ ನಮಸ್ಕಾರ ಸರ್, ನಾ ವೆಂಕಟ್ ನಾರಾಯಣ್ ಸರ್.
ವೆಂಕಟ್
ಸರ್ ನೀವು ಆಯುರ್ವೇದಿಕ್ ಅಂತ ಹೇಳಿದ್ರಿ, ರೂಟ್ ಅಂತ ಹೇಳಿದ್ರಿ. ಸೊ ಇಟ್ ಈಸ್ ಅ ವೆರಿ ಬ್ರಾಡ್ ಫಿಲಾಸಫಿಕಲ್ ಮಾರಲ್ ಅಪ್ರೋಚ್ ಅದು. ಕ್ಯಾನ್ ಯು ನಮ್ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಸಿಸ್ಟಮ್ ನಲ್ಲಿ ಲಾ ಇಸ್ ಅ ಮಿನಿಮಮ್ ಆಫ್ ಮೊರಾಲಿಟಿ ಅಂತಾರೆ. ಈ ಸಿಸ್ಟಮ್ ಅಲ್ಲಿ ಯಾವ್ದಾವ್ದೋ ಒಂದು ಆತರ ಅಟೆಂಪ್ಟ್ ಮಾಡೋ ಒಂದು ಉದಾಹರಣೆ ಕೊಡಕ್ಕಾಗತ್ತಾ ಸರ್, ಯಾವ ತರ ಮಾಡ್ಬೋದು ಅಂತ?
ಏನ್ ಕರಪ್ಷನ್ ಇದನ್ನ ಕಡಿಮೆ ಮಾಡಿ
ನೀವು ಇದು ಅಲೋಪತಿ ಆಗಲ್ಲ, ಇದು ಆಯುರ್ವೇದಿಕ್ಕೆ ಹೋಗ್ಬೇಕು ಅಂದ್ರೆ ಆಯುರ್ವೇದಿಕ್ ಯಾವ್ದಾದ್ರು ಒಂದು ಉದಾಹರಣೆ ಸರ್?
ಬಟ್ ನಂದು ಏನು ಅಂತಂದ್ರೆ ನಾನು ಹೇಳ್ತಿರೋದು,
ಹಾ ಸರ್,
ಈಗ ಏನ್ ಕೇಸಸ್ ನಾವು ಅಬ್ಯೂಸ್ ಆಫ್ ಪವರ್ ಕೇಸಸ್ ಅಂತ ನಾವು ಕೋರ್ಟಿಗೆ ರೆಫರ್ ಮಾಡ್ತೀವಲ್ಲ,
ಹಾ ಸರ್,
ಅದನ್ನ ರೆಫರ್ ಮಾಡೋ ಮೊದಲು ಸ್ಕ್ರೂಟಿನಿ ಲೆವೆಲ್ ಸಾಕಾಗ್ತಿಲ್ಲ ಅಂತ ನನ್ಗೆ ಅನಿಸ್ತಿದೆ. ದಟ್ ಈಸ್ ದ ರೀಸನ್ ವಿ ಆರ್ ಗೆಟಿಂಗ್ ಮೋರ್ ಕೇಸಸ್ ಟು ದಿ ಕೋರ್ಟ್. That will overburden the court.
Okay.
In the result, even you have participated in several trials. You know how the things happens.
Correct, sir. Correct.
ಅಲ್ಲಿ ಏನಾಗುತ್ತೆ, most of the time is wasted on unnecessary things. ನಿಮ್ಗೆ ಗೊತ್ತಿದ್ದಂಗೆ ಜಿಂದಾಲ್ ಚೇರ್ಮನ್ ಅನ್ನು ಕರೆದ್ರು.
Correct, sir. Correct.
What was the necessity? ಅವ್ರು ಅಲ್ಲಿಂದ ಚಾರ್ಟೆಡ್ ಫ್ಲೈಟ್ ಅಲ್ಲಿ ಬೆಂಗಳೂರಿಗೆ ಬಂದು ಬೆಳಿಗ್ಗೆಯಿಂದ ಸಂಜೆವರೆಗೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕಾಯ್ದು ಕೊಟ್ಟಿರೋ ಎವಿಡೆನ್ಸ್ ಏನು, ಈ ಲೆಟರ್ ಅಲ್ಲಿ ಏನಿದೆ ಅಂತ.
Okay. Okay.
ಈ ಪ್ರಾಪರ್ ಆಗಿ ಆಗಿದ್ದಿದ್ರೆ things could have, you can filter only strong cases you can put up for trial and get the proper conviction.
Okay.
That's what I'm saying.
Right, sir. Thank you. We have Mr. Parameshwar.
Then the fear will. Then the fear.
Mr. Naik.
Yes, sir.
I have two queries. One is regarding the police officer registering the case under Section 13E of the Prevention of Corruption Act, taking an authorization under Section 17 of the Prevention of Corruption Act, continuing the investigation and filing the charge sheet. So that means officer starting right from the registration of the complaint till the filing of the charge sheet. Then what is your take on the recent judgment of the Apex Court in Mohanlal's case? In reference to the officer conducting the investigation and filing the charge sheet.
ನನಗೆ ಕ್ವಶನ್ ಕರೆಕ್ಟ್ ಆಗಿ ಅರ್ಥ ಆಗಲಿಲ್ಲ. ಅಂದ್ರೆ ಸೆಕ್ಷನ್
ಇಲ್ಲಿ ಒಂದೇ ಆಫೀಸರ್ ರೈಟ್ ಫ್ರಮ್ ದ ಬಿಗಿನಿಂಗ್ they got by the Mohanlal's case, wherever there is an adverse inference, then it should not be done by the same officer, registration of the complaint till the filing of the charge sheet.
Yes.
So now what is your take on that?
PC actually, the reason they say,
yes,
for 13(1)(e) authorization from SP is required.
Correct.
SP is required because the protection is granted to have higher level of responsibility. That is the reason the man who is submitted the source report is not authorized to investigate. The man who registered the FIR is not authorized to investigate. Usually, by a specific order, a third officer is given to maintain the independence.
Okay, that's fine. Now, my second query is, what is your take on 17A, the new insertion, Section 17A of the PC?
I feel it is required. It is required because that is the reason I said when I was answering Venkat Narayan's question. See, when you start prosecution, you are playing with the life of a public servant. You have to have the higher responsibility, higher degree of scrutiny, and you have to avoid all these marginal cases. You have seen so many cases gets acquittal. Why? See, one of the cases where you and me have appeared,
Correct.
the two public servants are acquitted. Why? They are not aware. One is Bengali, one is Tamilian. You are requiring them to read the Kannada document. See, they have taken the opinion of an advocate. They have taken the opinion of a valuer. And there is no procedure or there is no method where they can find out whether this property is mortgaged to someone else. And the only man who knew that document is fake is the man who submitted the document.
Correct.
See, they had used a little bit of common sense and find out whether the officers will be able to read this document, which is in Kannada. Then they could have avoided those two officers. Look at their fate. And they have lost the promotion. They had to be before the court for almost 10 years. And they lost their career. Ultimately, it is ended in acquittal.
Don't you think it becomes a mini investigation itself?
They have to do it, according to me. They have to do it. Because when you are playing with the life of a person, you have to do a mini investigation or mini small inquiry to find out the reality and go. Then what happens? Even the prosecution, they will get more convictions. Their credibility will be more.
Yes.
First thing you have seen, and I have also seen, majority cases they file for statistics. Once they file an FIR, whatever by the method, they will try to file a charge sheet. Why they should adopt that? If they feel there is no case, they should file B report. Why they should worry about the press?
Correct.
See, many of the administrative agencies, whether it is police or judiciary, they are afraid about press. What I feel, they should not worry about press. They should write to their conscience. Then only the real thing will come out.
Yes, I think I got the answer. Thank you.
Right, sir. Thank you so much. We can have one last question. I think we have our secretary who is raising his hand. Yes, sir. Please go ahead with your question.
Good evening, Naik sir.
Good evening. Yes.
It's a very wonderful insight to the act.
Thank you.
And the procedure involved. My only question would be, a complainant will not appear before the prosecuting authority in spite of many reminders.
Yes.
What will happen to that case in spite of it?
My feeling is
In a trap case.
In a trap case.
Yes.
Even then, it will be difficult for the prosecution to establish, because in a trap case, it is a watertight case for prosecution. They will have to establish both the demand, acceptance, as well as work pending. Unless the demand is established, there may be a person, another witness, the shadow witness. If his evidence is credible, I think in the absence of the complainant also can. But the court is to be very, very reluctantly accept that evidence, because unless the prosecutor has not supported the case of the prosecution, the complainant has not supported the prosecution, the demand cannot be established.
Okay. Shadow witnesses are there, in fact.
Yes.
Thank you.
Thank you, sir. Indeed, it was a very informative session. So we have come to the end of the session. So it's time to say thank you to you. And on behalf of Advocates Association Bengaluru, I extend my heartfelt thanks to you. Thank you so much, sir.
Thank you very much.
And now we'll be rounding off the session. Thank you so much.